Hi, everyone, and welcome to this afternoon's UB Law in Focus webinar. And thank you all for joining us as we look at the Americans with Disabilities Act today, the ADA, a landmark civil rights act that put disabilities on the map. The ADA has opened up all aspects of American life to individuals with disabilities. We will celebrate and reflect today on the ADA, looking possibly at employment, government services, public accommodations, private businesses and service providers, possibly transportation, higher education, housing, healthcare, voting rights. What has it and what has it not accomplished in the 30 years of the ADA's existence? I'm Don Stone. I'm a professor here at the University of Baltimore School of Law and the director of the Mental Health Law Clinic, and I will serve as today's moderator. Our webinar this afternoon is co-sponsored by the UB Disabled Law Students Association, and we very much welcome them to this conversation. Here to discuss this topic, we have three panelists with extensive experience dealing with issues of disability law. UB Law alum Greg Kerr and Amjad Solomon, and current UB Law student Dan Hodges. In addition, law student Hadassah Barrowley will be monitoring the chat for questions and comments. Just a little bit about our panelists briefly. Greg Kerr is a partner in the Baltimore law firm of Brown, Goldstein, and Levy, where his practice includes litigation to vindicate the rights of persons with disabilities in their pursuit for independent lives. He serves as counsel to the National Council on Independent Living and is one of the firm's attorneys representing the National Federation of the Blind. Greg graduated from UB Law magna cum laude in, I believe, 2006. So welcome, Greg. Amjad Solomon has in the past practiced in private practice, focusing on labor and employment law, including cases involving the ADA. Amjad is a 2011 graduate of UB Law, where he excelled in our moot court competitions. Currently, Amjad is an attorney advisor with the National Council on Disability, a federal agency that makes policy and program recommendations to various government entities on disability concerns. Dan Hodges, a third-year law student here at UB, expecting to graduate this May. Dan is also president and founder of Pieces of Me Foundation, which works to eliminate stigma associated with disability, physical difference, and chronic illness by providing resources and connections to individuals and families, as well as appropriate training to professionals in these spheres. Before we begin, I'd like to let everyone know that our next and final webinar for 2020, an election wrap-up 2 weeks from today, with UB Law Professor Kim Whaley and others to analyze the presidential elections and the outcomes as they know it on that date. Details are on the UB Law website. After a break from the holidays, the UB Law in Focus discussion series will resume in January with a, we hope, provocative discussion on structural racism in the transportation policy. So now let's begin our conversation about the ADA. We very much want to read your questions and comments along the way, so please use the question and answer function on Zoom to share your thoughts. So we will get to as many as possible. So I have a list of questions, and so I'm going to start off and ask Amjad, followed by Dan, for the first question. And it's a pretty open-ended question, and maybe just your initial thoughts. Why do you think America is better off due to the enactment of the ADA?
I'd be happy to answer that if I might. It makes things more equal for people with disabilities. It makes them a more integrated group of people into our society. It's essentially more fair. And it solved a lot of problems. And I'm not just talking about making ramps available on curves, which is very important. It solves problems that other people don't consider, that they otherwise wouldn't have dwelled on. For example, currency. We all use currency every day. We all have dollar bills in our pockets. How many people stop to think about someone with low vision or who might be blind, who can't count their own money because currency in the US is not something that has a tactile function on it. Other countries, it goes without saying that they would put a tactile function on their currency. Here in the US, it's not something we've achieved yet, even though the courts say that this is something that the federal government has to do, and the federal government said it would do it. It's kind of been we'll get to it when we get to it kind of thing. It's just one example of the many different kinds of problems that essentially make life unfair for people with disabilities. And without the ADA, I don't even know how society would begin to tackle these problems.
Okay, thank you. Dan, what are your thoughts?
I tend to look at it from two angles. First and foremost, obviously, as someone who is blind and has a connective tissue disorder, there have been opportunities such as attending UB that probably wouldn't have been available to me without laws such as the ADA. And the second, and I think often overlooked angle is, especially as we continue having this conversation as a society about diversity and inclusion, the community at large is far better off with us included in those elements, with us allowed and empowered to express ourselves, to fulfill our potential, because we have something substantial to offer. And in that way, the ADA not only benefits us, but it really benefits the entire global community by virtue of what we can contribute.
Thank you. Thank you both. My next question is for all three of you, and maybe we'll start with Greg. The ADA's made a lot of strides, as we all know, but where do you think disability discrimination is still commonly seen? Where is the stigma greatest?
Yeah, that's a difficult one because there are lots of different ways in which that discrimination still manifests itself. I mean, there's still architectural barriers that exist 30 years after the ADA. There are still employment barriers that exist. I encounter a lot of the latter in my practice. Another area where it's sort of a more cutting edge, although this is sort of less of a novel topic than it has been in years past, is access to technology, whether it be for blind or visually disabled citizens or for those who are deaf. We all use, MJ mentioned currency, something we use every day. Internet websites and mobile applications and things of that sort are things that we sort of take for granted. I mean, how many of us sort of, especially today, woke up and the first thing we did was look at our mobile device to see what the returns were for the election. So having things that are accessible and the techniques exist, and the law is pretty clear, although when the ADA was written, the internet as we know it did not exist. The way that the ADA has been interpreted is to include that, but there are still many websites and mobile apps that are not accessible, even though they could be. Voting, again, apropos of sort of yesterday and continuing today, a lot of us take for granted in many states, including Maryland, to be able to cast an absentee ballot for any reason whatsoever. But if you're blind, up until a couple of years ago in Maryland, you really had no way to do that independently and privately. And that's a battle that's being fought in dozens of states right now to make that equally accessible. And it's really going back to what MJ said about equality. It's presenting an equal opportunity that a lot of us take for granted.
Dan, what are your thoughts on where do you think disability discrimination is still commonly seen, and where is the stigma greatest? Is there a certain type of mental or physical disability that still has the greatest stigma associated with it, or not necessarily?
I think Greg's right on. I would add to it, if we're looking at a specific sector that I've been looking at, and I know Greg has been working well on it also, is the medical sector, where a lot of this stigma seems to originate. So working to improve our communication with them. As far as maybe the most impacted segment among the disabled population. I think it's those who have invisible disabilities, who have to make a conscious choice of whether or not to come out, what to disclose, how to disclose, and are thus kind of getting it from both sides. They're having the impact of the stigma, but they're also having the impact of never being fully allowed to feel comfortable within their own skin.
Thank you. MJ, what are your thoughts?
If I just build off of what Daniel started to say with respect to healthcare, it's just appalling how much work there's left to be done with respect to healthcare. It's just one example. And before I continue, let me just do what I have to do as a government employee and say that I speak on behalf of myself and not the agency I work for. I forgot to say that at the beginning. Yeah, building off of what Dan said, as one example, in my work, I came to discover that dental students in the US are trained to provide care to people with intellectual and developmental disabilities. And it's just another example, one of those things where you just, wow, I never thought that that would be the case in this country. But it was, at least. And in working on that issue, I looked up the model rules of professional conduct for dentists as drafted by the ADA, the American Dental Association. And it says that you cannot turn away a patient based on race, ethnicity. It did not say you can't turn away a patient based on a disability, which I found shocking. So that's something, the National Council on Disability worked on. We advised the American Dental Association that they had to revise their model rules, and that in turn changed the laws of several states, because a lot of states just copy and paste the model rules into their own law. And then we were able to go to the Commission on Dental Gradation and say, listen, you need to teach all dental students to treat people with IDD, or else you're literally graduating students now that will be in violation of some states' laws. And thankfully, both the American Dental Association came on board and the Commission on Dental Gradation came on board, but it's just shocking that that wasn't already the case, in the 21st century in the United States. And we see a lot of other examples along those lines within the healthcare field.
Yeah, and I'm sorry, Professor Stone, if I can, just to take off on that, I think it's an important point. I mean, one of the biggest things that I think the ADA has partially achieved, but I think still exists, particularly in the healthcare field, is this, different way of looking at disability. And the medical model of disability is essentially that a person with a disability is a broken person who has something wrong with them, who, maybe is worth our pity. And that's really the most you can expect, which is exactly the idea that the ADA was trying to defeat, was that, we all have different ways of accomplishing the same things, and sometimes reasonable accommodations, auxiliary aids and services, things like that are a way to, address the differences in the way we do things. And I think that, in the medical field, that tends to be the way that those practitioners are taught, is to adopt the medical model, which really, I think, is an area that needs to be seriously addressed still.
Mm-hmm.
Right.
Thank you.
How many doctors' offices don't have equipment that's accessible to people with disabilities? Something that's clearly within the purview of the American Disabilities Act, but still it's not yet a reality in many places.
So I wanted to follow up with MJed, and the ADA has been around for 30 years, and there's still a long way to go to improve the lives of persons with mental and physical disabilities. But this is also a time to celebrate the ADA, to celebrate its 30th anniversary. So I'm wondering if you have any thoughts on which areas of society have made the greatest strides since the enactment of the ADA.
Off the top of my head, I would say two. Just the physical reality that we all have today is so different from where it once was before the ADA, right? So I'm old enough to remember life before the ADA, and I think many of us perhaps take it for granted that once upon a time, there were no cut curbs, right? There were no buses that lowered for people that need the buses lowered. That's something that's all around us, and it's a change that's thanks to the ADA. That not too long ago wasn't the case. So that's definitely an achievement. And also just reasonable accommodations. We certainly have a long way to go with respect to making more reasonable accommodations and making reasonable accommodations reasonable, right?
Mhm.
For example, centralized accommodation funds would make it much more easy to be able to afford accommodations if you would just take the effort to make a central accommodation funds as opposed to a line item for every specific office of an employee with a disability that requests accommodation. But before we go too much on that tangent, just the fact that it's a much more expected thing that you could be working with somebody that has a disability and they have an accommodation and you don't think twice about it, that's thanks to the ADA, I would say.
Okay, thank you. So I want to ask one more question, and then I think there's a question from through the chat. So since we are a place of higher education, I wonder if Greg and Amjad and Dan have thoughts on maybe some examples of reasonable accommodations that have been provided in higher education, and maybe some suggestions for improvements. Where do we need to make improvements with respect to higher education?
Yeah, so this is Greg. I can speak to that a bit and yield to others about personal experience if they have some. But I mean, there are some real easy fixes that some educational institutions, including higher ed, really can do but don't. I mean, it's simple things like having the materials, whether that be in some written form or whether it be online. And again, that sort of ties back to the access to technology issue that is a big part of my practice.
Mm-hmm.
Things like Blackboard and these sort of other online course management systems, that, unfortunately, a lot of institutions did not vet for accessibility when they began. And obviously, if they're getting federal funding, one of the things that they're required to do, whether it's the Rehab Act or some other requirement, is that they make that technology accessible. And they're not getting the assurances from the manufacturer or the provider, or the provider's not really doing their due diligence on that, and the educational institution just takes it for granted that they're correct when they're not.
Mm-hmm.
So things like that are really day to day that really affect your access to the course. And if you're having to spend an inordinate amount of time trying to get access to the information or the quizzes or whatever is being presented, you're at a real disadvantage. And we've seen that over and over again in our practice. We were in extended litigation with Florida State University a number of years ago with two really brilliant blind students who were pursuing, very advanced science degrees. And, there were techniques to make, tactographs and, the math materials accessible that, Florida State just was not doing. And so it required litigation to fix. And that's one of the issues that I think still exists with, implementation of the ADA, is that while the law is clear, it's not always done. And there are so many instances of discrimination that exist and only so many lawyers and advocates to go around to do it, that you still see a lot of issues like that crop up that unfortunately need to see litigation to be fixed.
Thank you. Anybody else have any thoughts on this last question?
I was just going to add that just solving problems before they arise to begin with. For example, we became aware that several medical schools in the US don't have non-discrimination policies drafted in place within their respective institutions, right? So the ADA works when somebody sues under the ADA, right? And if you don't have the money to sue or the time, then you're at a loss, right? But if an organization or a school, in this example, already has its own non-discrimination policy drafted in place, then it's likely that school is going to try to follow that policy, right? So that is something that's very crucial, is that schools make sure that they have non-discrimination policies drafted in place, something that they can hand out so that students can see what their rights at that institution is. Because in the absence of being able to sue, you want to at least be able to say, hey, this is what your handbook says. Can you please do it?
Okay, thank you.
I think also, we want to see more, or really all programs, include us in the diversity and inclusion language, and those programs where it comes to even having our history be part of the broader discussion of the rights that honestly haven't been protected in the past. I think the greater community doesn't have really even a fundamental understanding of that. And I think beyond that, one thing I've seen that's been a real struggle is students who, say, come into law school who may not have needed accommodations in the past are finding themselves in need of them now and don't know where to go.
Right.
So that's something that could be addressed proactively, as well as just a general understanding among our fellow students and faculty that getting an accommodation does not in any way, shape, or form impact the assessment of our ability to master a material. These are tangential things. These are not getting to the core competency of, do we know what we're doing and are we good at what we do, which is the real point of the assessment. That's not affected by an accommodation.
Okay, thank you. I'm going to turn the podium over to Hadassah, at least for a few moments, and I believe she has either a comment or a question from the chat.
Hi, I actually have a bunch of questions are coming in, but before we get to the questions, I just wanted to draw everyone's attention over to the chat. There's a link to the Pieces of Me organization in case if you'd like to learn more about that, you can check that out in the chat. The first question I have for everyone here today is, do any of you fear that the increasingly conservative U.S. Supreme Court will find occasions to limit the rights of individuals with disabilities?
Yes.
Yes. To expand on that, I mean, just speaking from my own personal practice, I mean, one of the access to technology issue in the websites and mobile apps in particular is that there's what some characterize as a circuit split. And at some point that issue will find its way to the Supreme Court. And, we're not always 100% confident that the Supreme Court, particularly as presently constituted, would necessarily get that issue right. But we're confident in the legal arguments nonetheless, but that is one particular area where I do have some concern.
I want to add to that as well. This ties into what we've seen in the last several years with these notice and cure legislative efforts, which basically would really gut the ability of us to take action on violations of the ADA without going through a mile of red tape. And they're not based off of businesses not wanting to do the right thing per se. They're based off of a fundamental misunderstanding of what the ADA requires and how the whole process works, and the proactive steps that can be taken that would really bring everybody to the table. And so as we see efforts like that continue to go forward, there is a very striking possibility for bad law or bad consequences to come forth out of that.
Thank you all for your comments. I wanted to shift gears a little bit and look at employment, at the employment arena. And I wonder if any of you, maybe start with Greg, have an opinion on which aspects of employment need the most, are in the greatest need for improvement. Is it the initial recruitment and hiring? Is it accommodating current disabled employees, or are there issues with termination that are the greatest challenge? And you could, of course, say all of the above, but is there one particular part of the employment setting that you think maybe needs the greatest, improvement?
Yeah. This question's a bit like asking to pick your favorite child. It's really hard to do. There's a lot, I think, that is clear in Title I of the ADA, which covers employment, that is pretty clear-cut and implementable for employees that's not being done right. It's easy stuff like the reasonable accommodations that MJed was talking about earlier on. You're supposed to have an interactive process with, between the employee and the employer, and you figure out, what's necessary to allow you to accomplish the essential functions of your job. And there's a lot of pushback for any number of reasons, including, the fact that there's, not enough money in the budget for whatever you're asking for, or we think that you're asking for someone else, to do your job for you. And a lot of that is really just a mistaken interpretation of the ADA, whether intentionally or otherwise. to sort of avoid, having to do what is required under the law. And I think a lot of it has to do with this idea that some of the other panelists have talked about, which is there's this perception that, accommodation's an advantage. And it's not. I mean, that's absolutely the opposite way to think about the issue. One other employment beyond sort of Title I of the ADA related issue in employment is the Fair Labor and Standards Act, which still to this day permits sub-minimum wage for workers with disabilities, which is just a travesty in our time. And our firm and a lot of organizations are actively pushing back on that beyond the legislative approach that's being carried out, but to litigate the appropriateness of that exception to FLISA. And we hope to make some progress on that, are making progress, but that really can't stand in 2020.
Okay, thank you.
I agree with Greg Moore. I mean, it's just appalling that some people are paid 5 cents an hour. And I understand that there are a lot of people with disabilities out there who come and they'll say, like, listen, don't take away my job. I know I'm getting 5 cents an hour, but it gives me an opportunity to get out of the house and to contribute. Well, yeah, but you should get paid more than 5 cents. We want to reach a point where people are getting jobs and getting paid to do the work that they're doing.
Right. Yeah. I mean, that's absolutely, I mean, the whole idea was to sort of, for people who really were not going to be able to engage in competitive employment, this is a way to at least do something, which I think is somewhat of an outmoded idea. But there's a lot of people getting mischaracterized and miscategorized into that category so that they can be paid less, even though they really could get paid more. And one of the policy ideas behind Title I is to sort of encourage full employment of people with disabilities. That the unemployment rate among people with disabilities is astoundingly high and unnecessarily high. There's no good reason for that, and a lot of it could be cured by better proactive approaches by employers. And that's good for everyone. That's good for the person with the disability, becomes more independent in their life, and also less dependent on public benefits and other things. So no matter which end of the political spectrum or legal spectrum you come from on the issue, full employment for people with disabilities is a boon to everyone.
And to build on Greg's point there, when we're talking astoundingly high, you can pick your measurement of both the employment rate and the number of people with disabilities, but any even conservative estimate would say there are literally millions of people who are capable of working who are currently barred from doing so under these circumstances. And there's no good reason for that.
Okay, thank you. I wanted to ask a more pointed question about reasonable accommodations, really one of the cornerstones of the ADA. So, as you know, disabled students, a student with a learning disability, a mental illness, student who's blind, has in all likelihood received accommodations in elementary school and high school and college and law school. And now they're ready, a disabled individual is ready to enter the workplace. And so my question to all of you is, should a person, let's say a lawyer, an attorney with a disability, expect a reasonable accommodation in the workplace? So for example, should a law firm be required to provide extra time to complete tasks, less stressful assignments possibly, paralegal assistance, and then of course on the other side, should the wages be lowered if they may take longer to accomplish a particular task? So I know that's a pretty open-ended question, but on the other hand, it relates to lawyers and disabled lawyers specifically. So I know MJed did have, at least early on in our discussion, an opinion on this. I'll maybe have him start if he'd like.
Well, I mean, so per the ADA, it hinges on whether the accommodation is reasonable, right? So if it's reasonable within a law firm to give additional time, then there's no reason not to. And I know that the term reasonable is one of the first things you learn first year at law. Is like, what is reasonable, right? Because you see that word pop up a lot throughout law. But it's pretty obvious whether or not something is reasonable. It's pretty obvious if an assignment has to be submitted by Thursday at 5, or it can wait until Monday at 5. That's something that's going to be pretty easily known. So wherever a reasonable accommodation should be made, can be made, it should be made.
Thank you. Anybody else have any thoughts on this question?
Yeah, I mean, I guess one thing that that we see in a lot of current law practice is the access to the software and the different programs that we use as lawyers, whether it's timekeeping software or Adobe PDF or whatever. You really need to, as a law firm or as any employer or as any institution of higher education, as we were talking about before, anticipate the need that at some point you will have an employee with a disability who needs to have access to that and acquire the accessible materials ahead of time instead of waiting for someone to come along and say, oh, well, we're not prepared for this. And so that, in our own firm's experience at Brown Goldstein and Levy in looking for accessible timekeeping software, which we knew we needed, we have lawyers with all different kinds of disabilities serve in our firm at various points. We needed them to enter their time. We needed them to be able to do the work and access Westlaw and things like that. You need to make those things accessible, but unfortunately the marketplace has been very slow in catching up. And so we've had to do a lot of aftermarket modifications to make sure that the things that are out of the box, not accessible, can be made so. But that's our obligation, not only because the law says so, but our firm culture is such that we do that in any event. But I suspect that there's lots of firms that may not necessarily have done that, and they will be playing from behind, unfortunately, which I think tends to have an unfortunate consequence flowing from that, gee, it sort of feels like we've got to do a lot to bring this person on board. Is that something we really want to do? And then it really cuts down on the number of lawyers with disabilities in our ranks, cuts down then even further on judges with disabilities on the bench, which we need to have. So there's a real domino effect from just a small thing like that.
Mm-hmm. Thank you.
If I could, I just want to reframe the question here a bit and just say, good leadership is providing the best circumstances reasonably possible for all of your employees to succeed.
Okay. Thank you,
So
Dan.
it's not just a matter of, for us, it's for everybody. So we're part of that holistic view of providing a good foundation for success.
Actually, you know what? And that's actually a very good point, because a lot of times changes that come about as a response to the American Disabilities Act end up benefiting society as a whole, right? Oftentimes. So and there's a million and one examples of that. And just take curb cutting, for example. Initially it was meant for people that have wheelchairs, but I'm sure everybody here, when they're walking across the street, they head for that curb cut to get up the sidewalk, right? And that's just sort of like a small, almost funny example of the larger reality that when you make things accessible for everybody, society as a whole benefits typically.
The next question I'm going to ask, if Dan wants to start this conversation, and it is, what should a disabled person do? Might be a wheelchair user, a blind individual. What should a disabled person do if a restaurant or a barber shop or a grocery store or a law firm is not architecturally accessible, not in compliance with the ADA? Should they boycott the establishment? Should they go to the press? Should they file a federal lawsuit? So sort of what's your sort of strategy for how to address an individual establishment?
Well, and this is something and I'm sure everybody else in similar shoes encounters virtually on a daily basis.
Mm-hmm.
And so to me, the strategy is trying to hold my own in the sense that remembering that it's not a reflection of my worth or value as a human being, and I don't have to compromise on that point, while also looking for the best way possible to communicate my needs and the advantage of meeting those needs to whoever is out of compliance. And then you bring on a slew of strategies from that point.
Yeah, if I can just add to that,
Yeah.
I mean, there's lots of different ways to try to address the problem, and not everything needs to be a lawsuit. I mean, a lot of times my clients prefer to take an educational approach that, perhaps even at 30 years hence the passage of the ADA, this particular business needs to be educated despite all the information that's out there, including what the Department of Justice makes available to small businesses to be compliant. Let's fix the problem. And then if you are truly in a position where you're going to fight us on even doing what's, really clearly your obligation, then obviously we're going to have to take other strategies into consideration. And that could involve all of the above, of what you mentioned, Professor Stone. But the fact is, as I mentioned before, there are far too many businesses, employers, schools, whatever, covered entities under the ADA. You can't possibly get them all. And unfortunately, there's a very significant feeling in among sort of the defendant class, if you will, that I'll just wait until someone sues me and then I'll deal with it. I'll try and moot the claim by fixing whatever the issue is, and then it'll go away. Because under the ADA, particularly in public accommodations, Title III, you don't get damages. So, you can only sue for injunctive relief. If they fix the barrier, then that's it. And then, if you hired a lawyer who's invested a lot of time into trying to come up with injunctive relief that gets mooted out, it really makes it difficult to get competent counsel to pursue those.
Okay, thank you. I'm going to turn to Hadassah again and see if she has another question from the audience or comment.
I have one question here. At some point, someone mentioned that there are only so many advocates to go around. If a new lawyer is looking to specifically assist with pro bono opportunities in this field, what would you suggest?
Yeah, I think I made that comment. So, there are protection and advocacy organizations in every state that are federally created. And, Maryland has an excellent Disability Rights Maryland is the organization that, we have a lot of great colleagues doing important work over there. But, they're sort of like the Public Defender's Office or legal aid, far too many cases and not enough hours in the day. So I'm sure that they're always interested in volunteers. There are other advocacy organizations, like the local Centers for Independent Living, who might be interested in things like that. So those are maybe two ideas. And then someone can obviously reach out to me offline if they'd like. My email address is on our firm's website, browngold.com, and we can I'd be happy to discuss ways you can connect.
Thank you. Here's a question that anybody who would like to answer, please feel free. And it is, again, a specific question involving a blind teacher who has applied to teach sighted students in an elementary school or possibly a high school. What might be some of the challenges for both on the school official side, questions parents may raise, and some of the challenges for the disabled individual?
So I can say, I don't want to bogart all the time, but I briefly represented a client who was in exactly that situation, and taught in a school in Philadelphia. And sort of one of the first battles that you fight as that teacher is sort of the same fight that a lot of blind parents fight, which is, you can't possibly be expected to supervise, blind children or students because you can't see what's going on. I mean, there's a lot of things wrong with that, including the assumption that blindness means no vision whatsoever. There's a lot of, residual vision among blind people. But in any event, even if you are totally blind, there are lots of ways to adapt to your environment. And my client in particular, who had special education students, and so maybe a little bit more on her plate, she really adapted well, was an excellent teacher. And really the only problem that she had was getting access to the materials that her students were getting in advance, so that she, that were accessible, so that she could teach her own students, and so we encountered a lot of issues about sort of, whether the school had to do that or whether she had to pay the money herself or, do all the legwork to get it done. But once you're sort of allowed to do what you do well, with the proper accommodations, which don't take a lot of thought, you know, but some thoughtfulness. There's no barrier. You know, blind teachers exist all over the country, including my client, and do an excellent job.
So, Craig, just to follow up, what kinds of arguments did you hear from school officials, either concerns about safety if there was a fire drill, or student discipline, or the challenges of grading students? What kinds of, were those concerns raised by school officials, or were there others?
It wasn't so much those issues, thankfully. It was mostly when we were seeking the accessible materials that either we don't know where to look, which really takes you 5 minutes if you, you know, anybody gets on Google, you know, can find the different repositories and libraries that have accessible materials, and getting in touch with the publisher is a pretty easy solution. And then we had the money fight, you know, about how much it was going to cost. And you know, you get the argument that unfortunately a lot of employers come at you with, which is, you know, well, our budget in our particular school is X. And what they really need to be considering is that there's a much bigger pool of funds that really go into the undue burden standard for determining whether the requested accommodation is going to cost too much or be too administratively difficult. So again, these are just things that employers get wrong. That's the easy stuff in the regulations and in the statute.
Thank you. I want to turn our attention back to employment, the job interview. A teacher or a police officer, somebody applying to be a teacher, or somebody applying to be a police officer who has a hidden disability. It might be a mental illness, for example. What's your advice to that applicant for a job who has a hidden disability about when, or if at all, to disclose one's disability, and if you believe that it should be disclosed, at what point in the interview process and or in the once employed process should that disability be disclosed by the individual?
I think for me, the first question I would ask that person is what they're personally comfortable with, because depending on the length of time or other circumstances, if they've had the diagnosis or a million other personal factors that can play in. I mean, ideally, we would love to see a world where that kind of self-disclosure would be affirmed instead of be one more strike against you, but we're honestly not there yet. So I think assuming the person's comfortable, maybe get through that first round of application, and then bringing into the interview process and try to treat it as an asset if they think the conversation is headed that way, but also reminding people everywhere along the path, you're not obligated to disclose unless you feel like it will further empower you or bring something to the table.
Okay, thank you. Now, I hesitate bringing this question up to the panel, but I'll do it anyway. Have you seen any public backlash or resentment on the part of folks who are not disabled, believing or claiming that folks with disabilities may get some unfair advantage in the workplace, in higher education? Any thoughts on what you've seen, what your thoughts are on sort of the public backlash from what the ADA requires?
I know I certainly have. I've experienced it throughout my academic career and throughout employment, where you have the perception of, like we've talked about earlier, accommodation meaning getting something extra or getting an unfair advantage, which it certainly isn't. Or then also, you know, I mean, my ex and I had Child Protective Services beat us home from the hospital simply because we were blind parents. And the perception was out there that maybe we'd skate by, but we couldn't monitor a child, which, you know, we brought that child successfully through cancer treatment, despite the fact that we were watched like a hawk. So there was definitely public backlash there. And a lot of it, again, stems from the stigma. It stems from the misconceptions of, we don't know how you could do this, therefore we don't think you can. and it's or the idea that accommodations or accessibility is unduly burdensome. So much still comes from that.
Thank you. Greg, do you have any follow-up comments?
Yeah, I mean, a lot of what Daniel just said sort of strikes me as what I hear day in and day out from my clients. I mean, you know, the idea that really the paternalism that exists, and this idea that, you know, I'm going to think about what if I'm trying to think about what a blind person's capable of, as a sighted person, I'll just close my eyes, and that will be a sufficient test to determine, you know, what you're capable of. Well, that's completely wrong. You know, you learn non-visual skills as a blind person, and you figure out how to exist and live in your world. And so there's that. And then there's this entirely, sort of defense-oriented reaction to all of the litigation efforts to enforce the ADA, particularly what you hear, the catchphrase drive-by lawsuits, and that, there are serial plaintiffs and so forth. I mean, while certainly I would not support anyone who does not have a good faith basis for making a claim and going to federal court or any court to tie up judicial resources and so forth, as I said, there's a ton of non-compliance out there, and bravo to the people who actually take time out of their lives to try and enforce the ADA when there are violations, but they get slapped with that label of being a vexatious litigant or a serial litigant, when all they're really trying to do, if they're doing it the right way, is to educate and correct issues, and make an example, so that when other businesses see that happen, they say, well, gee, I better get in line, because I might be next.
Thank you. I wanted to put some humor into our conversation, and I wonder if anybody has any humorous anecdote on how the ADA might have impacted a person with a disability. And I know Greg at least indicated he had something humorous to share, so I'll turn it over to Greg first.
Well, a little unusual, perhaps. I don't know if anyone else finds this funny, but a lot of my friends were really interested that a number of years ago, I handled a case on behalf of a number of students going through their non-visual blindness training program. And part of the process of becoming, fully confident in your abilities is to, do an exercise where you go and you navigate to where you want to go, and you all have an activity with your fellow blind students, and you have a good time, and you come back. And one student chose that he wanted to go play paintball, and I thought that was great. I'd never played paintball, but it sounded like fun to me. But unfortunately, they were turned away on the idea that, well, you're blind, you won't be able to see what you're shooting at, you won't know where people are, you might shoot someone, which I understood, even though I hadn't played it. It was kind of the point of paintball. So in any event, we really had to do a lot of education in that case, and fortunately we got to a point where I think the business owners understood, the mistake that they had made. But for every one of those, I think there's many, many more where the folks just carry on with the wrong-headed notions about disability. So I'll always remember that case and get some good laughs from that. So thanks for getting me a chance to talk about it.
Well, I'll also finish off. I mentioned a few minutes ago about CPS beating his home because you had a couple of hospital workers who literally refused to understand that blind parents were capable. Well, the humorous part of this is the social worker arrives a couple of days later, comes in, looks and says, there's no drugs here. The place is reasonably clean. You guys are doing well for new parents. Why am I here? Opens up the file. Because you're blind? You got to be kidding me. I'll take care of this. And then we had a friend going forward. So that was the happy and humorous end of that story.
Good. I've been involved in disability law as long as I can remember. And my first job out of law school was working in Virginia's Disability Rights Office, the Protection and Advocacy Office, in the late 70s. And when a non-disabled person parked in a disability parking space, the approach was, at least for some of us, there was a note put on the dashboard, you took my space, I took your air, and people would let the air out of the tires of non-disabled individual parking in those spaces. I thought that was rather fun. Approach. So, Hadassah, do you have maybe one more question or comment? If not, I'll let the panel give their final thoughts. But if you have one more question, I think we might have time for one more.
Yes, I have one comment and then a question. One comment regarding the language of hidden disability. Someone wanted to remind us that the language is invisible disability, not hidden disability, as this is considered a derogatory way of thinking for the person who may feel that they are hiding or embarrassed by this.
Thank you.
And then I have a question regarding the intersectionality of disability and immigration. We hear horror stories all the time of immigration officials taking medication away from undocumented immigrants or treating people with mental health challenges in a horrific manner. There's also a story of a man who failed his citizenship test after it was not offered in Braille, despite him requesting it. What protections exist for immigrants?
I would say, but the same ones that anyone else has. The ADA is not solely available to citizens. It's available to anyone, and so I would see no reason why the same kinds of protections wouldn't exist for immigrants. And in fact, these are a lot of the different policies that I think the ACLU recently has filed some litigation to address the disability aspect, the disability discrimination aspect of some of the immigration policy that the current administration has implemented. I haven't had a chance to review the filing, but I think that a lot of it's premised on these ideas, whether it's the ADA or the Rehab Act, Section 504, is that your immigration status does not determine whether you get to sort of enjoy all the same protections that everyone else does.
Thank you. Any other comments on that last question? Okay, so I'm going to give each panelist a few moments to just maybe share your final thoughts on where do we go from here. So Dan, would you like to start?
Sure, and I'll start by thanking you for letting me be part of this. It's been a pleasure. The ADA is a bill that made a significant amount of progress, but like with any other civil rights law, there's always room to expand the stakes and to fill in the gaps within the framework that we've built, much like every other minority has had to do. And we're at that point where we're still seeking legitimization, we're still seeking affirmation, we're still seeking a real, authentic place at the table, and we're getting there. But I hesitate to say that the ADA is, it was a starting place, and we need to always bear that in mind. One of the reasons why I was crazy enough to co-found a nonprofit in the middle of law school was because there is so much work to be done, and there are particularly needs among those with invisible disabilities or multiple conditions, disabilities like myself, or others who are simply out there seeking a diagnosis, who still don't feel like their needs are being met. And there's a great amount of work to be done, but there's also so much potential, so much human potential that everyone is going to benefit from as we bring everyone in and allow them to thrive.
Thank you, Dan. Greg, you have some final thoughts?
Sure. Yeah, I mean, kind of what Dan said, the work is never done. The ADA is a civil rights law, and we certainly have not accomplished the full satisfaction of all of our civil rights. That will continue to be a struggle in our lifetime and probably beyond that. The important thing is that we have people who are willing to stand up for their rights, people who are willing to advocate on behalf of those whose rights need to be protected. And I hope that, among the audience are some of these lawyers or lawyers in training who aspire to do this kind of work, because there's plenty to do. There's lots of places to have an impact, whether it's in private practice or in nonprofit. And I just really hope that people take a serious look at a career in this field, because you meet a lot of very interesting people, and learn a lot. I came to disability rights work sort of serendipitously in my career. It wasn't something I sought out. It was, I was expected to do free speech and that kind of work in the civil rights arena. And what I encountered at a steep learning curve of what the right ideas were in this field, and really began to understand a lot of what the panelists have been talking about today, that we are all much better off when we are allowed to achieve our full potential. And that's really what the ADA and a lot of its sort of companion laws, whether it's the IDEA or Rehab Act or whatever you name it, those are really just meant to have us all achieve our full potential. We're all better off that way. And it's been a pleasure being on this panel to talk about it.
Thank you. Amjad, final thoughts?
I just wanted to thank you for having me join today. It's been my honor and privilege. And I will just build off what Dan and Greg were saying, that the ADA is certainly a wonderful piece of legislation. I consider the most significant civil rights law to have passed since the 1964 Civil Rights Act. But as they both said, there's definitely a lot more work left to be done. I would encourage all UB Law students who are watching this right now to consider going to this field. It's very rewarding, as is potentially going into government service. And perhaps you can combine the two. If you do, I don't think you'll regret it.
Thank you. And as the moderator, I wanted to thank all of our panelists for your provocative comments and thoughts. And I wanted to also thank Christine Stutz, who is behind the scenes, the real organizer of this webinar and many other webinars here at UB. So thank you, Chris. And maybe a final question to Chris. There will be some in the audience who would like to reach out to individual panelists with questions, comments. What's the best way for that to happen?
They can email me, cstutz@ubalt.edu, which ought to be in your registration email. You can put your information in the chat. Sometimes people want, if we have a lot of links, people will request the links. So we will be sending out the video to everyone who's been here. And if anyone, they'll get an email as a follow-up. So if they would like to respond to that, then we can share whatever they need.
Great. Okay, and also thank you to Hadassah Barrowley for monitoring the chat. As a law student, I know you don't have a lot of free time, especially as exams are approaching. Also for Dan, thank you for taking the time as a law student. Busy time as we've now hit November and exams are right around the corner. So good luck in your exams, and thank you all for joining us today. And on that note, I will say goodbye.